Assalamualaikum to my dear lecturer Professor Madya Dr. Haji Muhammad Shahnawi bin Muhmad Pirus. Today I will be presenting a cybersecurity case involving Risk X, Sdn Bhd, and Capital Market Risk Advisor Sdn Bhd, also known as CMRA. This is a notable High Court case involving software copyright, confidential information, and allegations of conspiracy. To begin with the facts, RiskX Sdn Bhd was a software development company providing risk management systems for the financial sector. The plaintiff, RiskX, claimed ownership of a software system called Operational Risk Management System version point 6 (ORMS v.6). The first defendant, CMRA, developed a competing product called FRA, short for Financial Risk Advisor. Interestingly, several CMRA employees were previously employed by RiskX. RiskX then alleged that the FRA system was actually copied from its ORMS v.6 software and brought a suit claiming copyright infringement, passing off, breach of confidentiality, and conspiracy to injure. The key legal issues the court had to determine were whether RiskX owned the copyright to the ORMS v.6 software, whether there was copyright infringement by the defendants, whether the defendants committed the tort of passing off, whether there was a breach of confidential information, and finally whether the defendants conspired to injure RiskX. The High Court dismissed the plaintiff's case with costs. The court found that RiskX had failed to prove it owned the copyright to ORMS v.6 as the purchase from the alleged developer was not properly pleaded. There was no expert analysis provided to compare the software codes and prove similarity. The court also held there was no trademark or goodwill shown by RiskX to support the passing off claim. Additionally, the information claimed to be confidential was not clearly identified, and there was no evidence of unauthorized use. The conspiracy claim was based on suspicion alone, without concrete proof of a common intention to injure RiskX. Moving on to the analysis and critics. Failure to plead ownership properly, the plaintiff relied on evidence that it had purchased the ORMS v.6 software from a third party globally, but this was not pleaded in the statement of claim. No technical or expert evidence for infringement. The court noted that there was no objective analysis comparing the two software systems between ORMS v.6 versus FRA. Vagueness in confidential information claims. The plaintiff failed to specify what confidential information had been taken or misused. Weakness in conspiracy allegation. The claim or conspiracy to injure was largely based on suspicion and assumptions from RiskX, not actual proof of collusion. Cost award reflects frivolity of claim. The award of a cost against the plaintiff may indicate the court viewed the action as lacking substance or seriousness. These are the references used for this presentation. Number 1. RiskX Sdn Bhd against Capital Market Risk Advisor Sdn Bhd and ORS 2017 8 MLJ 475. Number 2. Copyright Act 1987 from Malaysia, Section 3, Copyright Work, and Section 42, Presumptions of Ownership. Number 3. Evidence Act 1950, Section 101, Subtopic 1. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. Other cases used for references including Coco against A. N. Clark, 1968, Petraware Solutions Sdn Bhd and Anor against Ritsoft Aktibolag and Anor, 2013, One Stop Software Solutions Sdn Bhd and Anor against Masterytech Sdn Bhd and ORS in 2009, Ho Tak Sian and ORS against Rota Research Laboratorium SPA and Anor in 2012. And that is all from me. Thank you.